My name is Richard Brand. I'm the chairman of the corporate department at Cadwalader, Wickersham, and Taft, which is the oldest law firm in the United States with over 400 lawyers practicing in the United States and Europe. Thank you first to Capital Link and to Bornosis for launching this very valuable initiative to inform, spotlight, and develop the shipping industry in Cyprus. Also, I wish to thank the leadership of Safe Bulkers and Safety Management, in particular Polis Hadjoanu, Lucas Barbaras, Konstantinos Adamopoulos, Ole Whitford, and Christo Magalau, who are all here today. Thank you for being a great client and for your support of my practice and of Cadwalader. We deeply value our partnership, and I'm proud to be here today to support the Cyprus shipping community of which you are a proud part. Today, with the time that I have, and I promise I'll keep it short, I'll provide an overview of the U.S. Foreign Corrupt Practices Act in the context of other global anti-corruption regimes, enforcement trends, and their recent application to the shipping industry. The shipping industry has been a focus of anti-bribery enforcement because of the global nature of the business, the involvement of agencies and third parties in the conduct of the business, and the high degree of contact between the industry and state agents. So on to an overview of FCPA. The FCPA imposes three distinct requirements. There's an anti-bribery requirement, which prohibits the giving, offering, or promising of anything of value, directly or indirectly, to foreign officials. A books and records requirement that's applicable to public companies that requires public companies to maintain certain accounting books and records so that all payments, whether to foreign agents, are properly recorded, and internal controls an internal controls requirement that public companies must devise and maintain a system of internal controls that provides reasonable assurance of accurate books and records and GAAP-compliant financial statements. Who is subject to the FCPA? You may think that if you're a ship management company in Cyprus, you're not subject to the FCPA because you have no nexus or very limited nexus to the United States. Courts have broadly interpreted the jurisdictional nexus between the United States and the FCPA to apply it to not just to U.S. companies, not just to U.S. citizens and residents, and not just to public companies whose securities are traded in the United States, but also to foreign companies and entities with a presence in the United States, really any nexus in the United States, as well as to non-U.S. agents acting on behalf of any entities that have any nexus to the United States. The anti-bribery provisions of the FCPA prohibit giving or offering or promising or authorizing, directly or indirectly, anything of value to any foreign official, corruptly, in order to obtain or retain business or otherwise gain an unfair advantage. Anything of value, what does that mean? Obviously, it covers gifts, cash, other valuable benefits, but it can also include intangible benefits, employment, travel, education, entertainment. There was a recent FCPA significant fine and settlement paid this year by J.P. Morgan, which had settled on relating to charges that the bank had hired 100 children and other friends and relations of Chinese officials to help win business in China. There's no de minimis exception. There's potential liability of the FCPA even for very small payments. Who is a foreign official under the FCPA? This is defined very broadly. It's not just officers or employees of a foreign government. It could also include state-owned actors. That could include a state-owned or state-run shipyard, for example. Individuals or entities performing government functions, members of the royal family or military, foreign political parties and political party officials, and officers and employees of public international organizations like Interpol, IMF, United Nations. The next slide. Some exceptions to the FCPA anti-bribery rules. gifts and entertainment, reasonable and good faith gifts, expenditures do not violate the FCPA because there's no corrupt intent. Those expenditures can include travel and lodging expenses incurred by or on behalf of a foreign official directly related to the promotion, demonstration, or explanation of products or services, or the execution or performance of a contract with a foreign government or agency. Gifts, so long as the expenditures are reasonable and have a legitimate purpose, such as because they're customary in the culture or related to the demonstration of the product, are also permitted. Such expenditures still must be legal in the relevant country, customary to the relevant country, made transparently and accurately reflected in the company's books and records. There's also an exception, which we don't include in the slides, but which is often discussed, which is an exception for facilitation payments, which is payments to government officials to obtain non-discretionary services on a more expedited basis. With respect to the internal controls requirements, which are applicable only to public companies, the objectives of these provisions are that the assets be safeguarded from unauthorized use, that corporate transactions conform to managerial authorizations, and that records are accurate. Interestingly, the fines and sentences associated, penalties associated with violations of the internal controls and the accounting provisions of the Act are actually greater than the anti-bribery provisions themselves. In terms of penalties, there we go. Criminal penalties are enforced by the Department of Justice in the United States. Civil penalties by the Securities and Exchange Commission. Under the criminal aspects, each violation of the anti-bribery provision can result in a maximum fine of $2 million for a company and $100,000 and 5 years imprisonment for individuals. Each violation of the accounting provisions can result in maximum fine of $25 million for a company and $5 million and 20 years imprisonment for individuals. So the accounting and internal controls aspects of the FCPA are significantly more onerous in terms of penalties. Civil penalties can include injunctive relief, cease and desist orders, penalties of disgorgement. There's no scienter requirement for public company liability. In addition, there are other collateral consequences for violations of the FCPA. Criminal and civil fines, imposition of an independent monitor, parallel law enforcement and regulatory actions. So often the U.S. government works in cooperation with local authorities and enforcement of local anti-bribery laws and regimes. Criminal actions against executives and employees, civil litigation, including shareholder class action lawsuits, reputational damage, disclosure of possible violations and enforcement actions in public filings, decline in stock price, and obviously legal fees. Although I'm not selling services to the concerned questioner earlier. The FCPA is obviously not the only anti-bribery regulation that the shipping industry needs to be concerned about or contend with. Other anti-corruption laws overlap and may be applicable even when the FCPA isn't, or they may both be applicable. UK Bribery Act, enacted in 2010, criminalizes bribery by UK firms, whether committed directly or indirectly in the UK or overseas, creates strict liability offenses for a company's failure to prevent bribery. There's broad jurisdictional reach that covers non-UK companies that carry on any part of their business in the UK. It criminalizes commercial bribery as well as government corruption, unlike the FCPA. And there is no exception for facilitation payments, again, unlike the FCPA. There are also significant anti-corruption laws in Brazil, Canada, China, OECD, and other jurisdictions. Industry risks. Shipping companies operate across the globe, including in many jurisdictions identified as high risk for corruption. The map there is Transparency International Corruption Perceptions Index, and think the brighter red colors are colors are countries that have perceived higher risk of corruption. The yellow or lighter colors, colored countries have perceived lower risk of corruption in the countries. Business risk, direct interactions with government officials. Direct interactions with government officials. I'll go to third parties. Third-party business partners also may interact with government officials, exposing shippers and their customers to potential liability. They include port agents, customs brokers, local transportation, subcontractors. Third parties are responsible for a range of activities involving contact with government officials, including payment of customs duties and managing customs disputes, document processing, permitting, inspections and certifications, berthing, storage, in-country road shipments. Skip these red flags. I'll make this available to anybody who asks for it, but I've included some recent FCPA enforcement actions against participants in the shipping industry. Panalpina, Conway, and others. Forward. I'll go right to some takeaways and lessons. So local subcontractors should be carefully selected, trained and monitored. Diligence and controls are necessary when retaining and paying agents and consultants to ensure that those payments are properly recorded. Executives' employees can be liable for failure to act, not only for authorization of payments. Heightened controls are necessary in high-risk jurisdictions, and enhanced procedures and controls should be used when doing business with state-owned entities. Thank you. Any questions?
Okay, thank you.